Hey guys, we got a big case that was filed in Texas for summary judgment, and it has to do with challenging the NFA related to suppressors if they're made and stay in Texas. They never leave the state. Great case. Also, before I jump into this, I want to let everybody know that tonight is Tuesday, the 7th of February, 2023. I will be having the State of the Union address live. If you aren't near a television and you want to see how much gun control he puts in this speech, he being President Bobo, I will have it live here. So I'll be live at 8:50 p.m. Eastern Standard Time. The address starts at 9 p.m. Eastern. And if you want to watch it, I'll have it linked down below and in the pinned comment as well. Now, this case is phenomenal. It's challenging the NFA based off of the marijuana case I talked about a couple days ago, and it's phenomenal. Before I jump into this video, I want to tell you about the sponsor of today's video, and that's the Sonoran Desert Institute. Guys and gals, many of us gun owners like to tinker with or repair or upgrade our own firearms. Well, why not turn that passion into a career? SDI is a distance learning institute where all of the tools and materials are shipped directly to your door. They have classes like ballistics, gunsmithing, armorer's courses, and even drone classes. Start the path at getting your certificate or your degree at the link down below, sdi.edu. Thank you to SDI for sponsoring this video. All right, guys, my name is Jared. This is Guns and Gadgets, the premier source for Second Amendment news. If it's the Second Amendment news you're after, you found your home. Hit that subscribe button down below, like the video, share the video, and let's get into this one. This is page 1 of the filing. Now, the Texas Attorney General, this case has been ongoing, but yesterday he filed for a summary judgment, meaning he wants the judge to address it right away. Let's go into the introduction part. It says the New York State Rifle and Pistol Association, Inc. versus Bruin establishes a new test for the constitutionality of firearm regulations. Just 4 days ago, the Fifth Circuit held that Bruin clearly, fundamentally changed our analysis of laws that implicate the Second Amendment, rendering prior precedent obsolete. And that's the U.S. v. Rahimi case that I will link above. And that is a big case, a huge case, where they said the Second Amendment prohibition on marijuana use is unconstitutional. Bruin requires courts to reevaluate Second Amendment jurisprudence. The National Firearms Act of 1934 was amended in 1968 to regulate for the first time the making of firearm suppressors for non-commercial personal use in Texas. But defendants cannot demonstrate any historical tradition that can be analogized to any feature of the regulatory regime that applies to the making of firearm suppressors for non-commercial personal use in Texas. Therefore, the statutes establishing that regulatory regime and defendants' rules and practices implementing and enforcing that regulatory regime are unconstitutional. See Rahimi, where it said holding that the government fails to demonstrate that 18 U.S.C. 922 G8's restriction of the Second Amendment right fits within our nation's historical tradition of firearm regulation. As a result, 922 G8 falls outside the class of firearm regulations countenanced by the Second Amendment. Wow, what an opening. It's saying, listen, Judge, you have to say this is unconstitutional because that case is the same type of case this is, and that was unconstitutional. And the Fifth Circuit, guess what? Texas is in the Fifth Circuit. Now let's get into some of this procedural history. The plaintiffs sued Stephen Dettelbach, director of ATF, and Merrick Garland, Attorney General of the U.S., in their official capacities. Plaintiffs seek injunction relief against enforcement of the requirements that they apply for and receive permission to make a firearm suppressor for non-commercial personal uses in Texas, pay a $200 tax on making firearm suppressors for non-commercial personal use in Texas, and register and place a serial number on firearm suppressors made in Texas for non-commercial personal use in Texas. So you see the theme, personal use, non-commercial use, right? Because that's key. Plaintiffs are not challenging other parts of the NFA or GCA. For instance, plaintiffs are not challenging regulations of rifles or handguns not regulated by the NFA. They are not challenging regulation of weapons regulated by the NFA other than firearm suppressors. Plaintiffs are also not challenging commercial regulations, such as regulations of transferring weapons in or manufacturing weapons for interstate commerce or licensing regulations. And that's the little carve out, because what Texas is saying, personal use, non-commercial, NFA doesn't cover it. And Judge, you have to rule on this because there's no historical text, history, or tradition to this, and it's great. The challenge statutes are unconstitutional as applied to Texans making firearm suppressors for non-commercial, personal use, and their continued possession of those firearm suppressors. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. United States Constitution, Amendment 2. The Second Amendment protects an individual's right to carry a handgun for self-defense outside the home. That was in Bruin. See also District of Columbia versus Heller. This right, however, is not unlimited. Our nation's historical tradition teaches that there are certain long-standing, presumptively lawful regulatory measures that the Second Amendment did not abrogate. After Bruin, rather than means and scrutiny, courts must assess whether modern firearms regulations are consistent with the Second Amendment's text and historical understanding. Stated another way, courts must first interpret the Second Amendment's text as informed by history, and when the plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Bruin has already been cited hundreds of times, mostly in cases that do not apply to anything resembling the challenged regulations. But a few opinions citing Bruin address issues that are closer to the issues in this case. It then discusses some of the cases. Of course, if you want more information on that, I'll pin this case down below so you can read it. It's 59 pages long. I'm going to show you one other thing and then we're going to wrap it up. The Texas AG says, making a firearm suppressor for non-commercial personal use is conduct covered by the Second Amendment. Although the NFA itself defines firearm suppressors as firearms, whether a firearm suppressor is or is not an arm is not the issue. Firearm suppressors are attached to the barrel of firearms. When one keeps or bears arms with a firearm suppressor, one is exercising Second Amendment rights, just as when one keeps or bears arms with a trigger or a detachable magazine or a scope, one is exercising Second Amendment rights. Regulating firearm suppressors, triggers, detachable magazines, or scopes is regulating conduct falling within the scope of the Second Amendment's guarantee. Regulating firearm parts, accessories, and things like firing ranges is regulating conduct covered by the Second Amendment's plain text. The Second Amendment covers more than regulations of arms themselves. Similarly, the First Amendment covers more than speech and press themselves. For instance, neither paper nor ink are themselves speech or press, but newspapers use paper and ink to exercise their rights of freedom of speech and freedom of press, just as citizens may use firearm suppressors, triggers, sights, detachable magazines, ammunition, and firing ranges to exercise their right to keep and bear arms. That is why newspapers cannot be constitutionally taxed on their purchase of paper and ink, except as part of a general sales tax on all goods purchased. It then goes on to say suppressors are very common, so they can't say that they're not in common use, so Heller applies as well. And here's the conclusion, this is what they're asking for. Plaintiffs request that the court grant their motion for summary judgment and A. Issue permanent injunctive relief enjoining defendants from requiring Texans to apply for and receive permission to make firearm suppressors in Texas for non-commercial personal use in Texas. B. Issue permanent injunctive relief enjoining defendants from requiring Texans pay a $200 tax on the making of firearm suppressors in Texas for non-commercial personal use in Texas. C. Issue permanent injunctive relief enjoining defendants from requiring Texans to register firearm suppressors made in Texas for non-commercial personal use in Texas. D. Issue permanent injunctive relief enjoining defendants from requiring Texans to place a serial number on firearm suppressors. E. Issue permanent injunctive relief enjoining defendant Garland from initiating criminal prosecutions of plaintiffs Schnitz, Martin, and Allen for making a firearm suppressor in Texas for non-commercial personal use in Texas without complying with the application, taxation, registration, or serial number requirements. F. Declare the following statutes unconstitutional as applied to the making of firearms by Texans, and declare the following regulations unconstitutional as applied to the making of firearms by Texans for non-commercial personal use in Texas. Award other and further relief as the court deems equitable and just, and in the alternative, the court should issue an injunction requiring the ATF to promptly approve or disapprove all Form 1 applications to make firearm suppressors without requesting additional information not already requested in the Form 1 applications as it existed on February 24th of 2022. So this stands to be a huge challenge with Bruin as the armor-piercing round, and the NFA being the target. Specifically for suppressors, you know it, non-commercial, personal use, made in Texas, used in Texas, kept in Texas. And this is good, because if this is successful, and we'll find out soon, then this is going to be big for getting suppressors out of the NFA. Now, I always get questions related to cases. How does that affect me here? This is a district level case, so in the federal system, it's step 1. Then in the appellate court, 3-judge panel, then the appellate court en banc, and then to the Supreme Court. So this is just the step 1 for these folks in Texas. But this first step could be instrumental and monumental. Just like the decision saying that marijuana restrictions based off of the Second Amendment in Bruin are unconstitutional, and how people who have a civil restraining order against them, disarming them without a conviction, is also unconstitutional. There's a lot of good things happening in the world of the Second Amendment thanks to the Supreme Court's ruling in Bruin, and it's just the beginning. If you want to follow this all along, I will chronicle it here on this channel. All you gotta do is hit that subscribe button down below and join this growing freedom family. Until we see each other again, be safe. Stay vigilant and carry a gun to keep you, your friends, your family, your community safe. I'll see you all on the next one. Take care.